arrested around 4:30 Tuesday morning on multiple drug charges. One of 16 arrested at the scene.
3 of them, I believe, were convicted felons. So if they didn't have weapons in their possession, they were around weapons.
According to BRPD, they all attempted to run upon their arrival.
There are individuals out there that started tossing their guns. Some started running. They were attempting to hide. There were a group of them that were attempting to hide.
The alleged suspicious behavior led police to search cars at the scene. They confiscated 14 guns, $79,000 in cash and drugs. The incident is being investigated by BRPD as well as the FBI, which could lead to federal charges. Golden was released on $75,000 bond Tuesday afternoon.
So they coming out right now. Go sit your bitch. What you want to get locked up for, stupid? Look at Tyler.
Tyler had me in the backseat stand with money on the plate. I said fan check. I said he took the fan check on. Who y'all know? I said my dick. I don't know him in 4K truck.
Stop playing.
He about to come out young.
Same here.
For my son, yeah. All right, yeah, that's right. All right.
Give him a hug, Kayla. I got it. Say thank for the supplies.
Give me a picture.
The rapper's attorney argues his client never had possession of the weapons or drugs because he doesn't own any of the cars on the scene. The attorney released a statement saying, in part, his client is innocent of all charges he was booked on last night and looks forward to defending himself.
Yo, what's up, people? We is back. Another day on Keep It G News. And then we're in Baton Rouge to talk about NBA Youngboy. I know a lot of people was wondering, especially after he beat that federal case, what was going on with the gun case in Baton Rouge? Because it seemed like to me at the time it just disappeared. But before I get into the video, make sure y'all subscribe to the channel. Donate to the channel if you can, because I took a lot of time on putting this video together. And I'm not monetized, straight up. But in this video, we got some updates on this Baton Rouge case. And it looked like to me, NBA Youngboy and his defense team just took a major L. Now before I get into the clip, I gotta explain to y'all what y'all ready to hear. This is legal court documents, so you're gonna hear some case numbers and everything, but I try to do the best I can to make sure y'all understand all the terminology. So you're gonna see little clips coming in and out explaining to y'all what y'all just heard. Now I'm gonna get y'all up to date before I run this clip for y'all. A couple months ago, NBA Youngboy defense team scored a major victory in this case where the judge decided that the state couldn't use the video footage that they retrieved from his cameraman SD card or USB. Y'all remember that? At that point in time, a lot of people was talking about, man, drop the case. But come to find out, the state of Baton Rouge at the time appealed it. They appealed. In this video I'm ready to play for y'all, this article I'm ready to read for y'all, is the court's determination on this appeal. But before we get to that part, I gotta catch y'all up to speed on Intro the case. Garden, a rapper professionally called Youngboy Never Broke Again, or NBA Youngboy, succeeded in suppressing a video that showed him a felon violating federal gun laws. The government had appealed, arguing that he had neither a protected property interest in the video footage filmed by a third party nor a reasonable expectation of privacy therein. We agree with the government and therefore reverse the district court's contrary judgment. Galton's company, Big 38 Enterprise LLC, hired Marvin Ramsey to follow Galton around to film his everyday life. Galton often requested that Ramsey share portions of his B-roll footage with Galton's record label, Atlantic Records, for use in music videos. More often, Galton edited and uploaded portions of the footage directly to social media. Either way, the footage was used according to Galton's preference for promotional purposes. Most of the footage remained unshared. On September 28, 2020, an anonymous 911 call reported several men with Uzis and other guns walking down a residential street in Baton Rouge, Louisiana. This was the second such report in 2 days. Police arrived at the scene and detained Galton, Ramsey, and others. The officers recovered a camera containing a memory card from Ramsey's person and several firearms from the surrounding underbrush. After obtaining a warrant, officers viewed video footage stored on Ramsey's memory card. The footage showed Galton holding a Glock pistol and gesturing with a masterpiece arm pistol equipped with a vertical foregrip. Garden is a felon. Based in part on that footage, a federal grand jury indicted Garden for possession of firearms following a felony conviction, 28 U.S.C. 922 G1, and for possessing a firearm that was not registered to him under the National Firearms Act, 26 U.S.C. 5861 D. Garden moved to suppress the video footage. The government argued that Garden could not suppress the video footage because he lacked blank. Officers obtained a second search warrant to search a camera bag located in a nearby vehicle. It contained additional memory cards that matched Ramsey's camera. A Fourth Amendment interest in it. 3 witnesses testified in support of Garden. A bank manager assisted to a payment from Big 3 Enterprise LLC to Ramsey, and 2 witnesses from Atlantic Records discussed Ramsey's employment as an around-the-clock videographer who recorded lifestyle footage for social media and music videos. Atlantic's chairman noted that Garden shoots a lot of stuff. He then determines where he wants to go up. But the unused footage is not reviewed by Atlantic. Ramsey did not testify. The district court reasoned that Garden had a protective Fourth Amendment interest in the videos on the memory card, although he lacked a Fourth Amendment interest in the memory card itself. The court also found the warrant fatally defective. Accordingly, the court suppressed the footage of Garden in possession of the firearms. The district court denied the government's motion for reconsideration. The government's appeal raising only the antecedent question of Garden's Fourth Amendment interest in the footage. We reviewed the district court's legal determination regarding a motion to suppress de novo in its actual finding for clear error. We view the record evidence in light the most favorable to Garden as the prevailing party, United States v. Massey, 761F. But Garden bears the burden to prove his entitlement to the remedy of suppression, Rutgers v. Illinois, 439 U.S. .128-130-132. The Fourth Amendment protects the right to the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizures. U.S. Constitution amend. Emphasis added. Those invoking the amendment can vindicate only their personal security against unreasonable search and seizures, not security in the property of someone else. And y'all see by now what the prosecution argument is in this hearing. They confiscated the memory card. What they're saying is they can search that memory card because that memory card does not belong to NBA Youngboy. And the defense is saying, though it don't belong to him, technically, it really is his memory card because his information is on it. So that's basically the basis of this whole hearing. It's all about this memory card. And they mentioned 2 articles. Rutgers versus Illinois, well, mainly 2 articles. Rutgers versus Illinois and Smith versus Maryland. But in this next clip I'm ready to play for y'all, y'all gonna hear the determination by the judge and why he felt as though that they can use this footage. The majority rejects Garden's argument and concludes that he had no subjective expectation of privacy in the video footage and failed to take normal precautions to protect his privacy because a person has no legitimate expectation of privacy and information he voluntarily turns over to third parties. See Carpenter v. United States, quoting Smith v. Maryland. Even if the information is revealed on the assumption that it will be used only for a limited purpose and the confidence placed in a third party will not be betrayed. United States v. Miller, 425 U.S. 435-443, 1976. This is so-called third-party doctrine. Carpenter, 138 S. CT at 2216. While I concur in the judgment, I disagree with the rejection Garden's claim on this basis. Per third-party doctrine, when a person shares information with others, the government is typically free to obtain such information from the recipient without triggering Fourth Amendment protections. More recently, however, the court warned against mechanically applying the doctrine, 138 S. CT at 2219. Carpenter clarified that while an individual has reduced expectation of privacy and information knowingly shared with another, diminished privacy interest does not mean that the Fourth Amendment falls out of the picture entirely. Quoting Riley, 573 U.S. at 392, the court explained that Smith and Miller, after all, did not rely solely on the act of sharing. Instead, they considered the nature of the particular document sought to determine whether there is a legitimate expectation of privacy concerning their content. The third-party doctrine is a poor fit for the facts of this case, as a comparison with Miller and Smith demonstrates. In Miller, the court held that a bank depositor had no reasonable expectation of privacy in the context of a check, financial statements, and deposit slips maintained by his bank, as the checks were not confidential communications but negotiable instruments to be used in commercial transactions, and the bank records contain only information voluntarily conveyed to the banks and exposed to their employees in the ordinary course of business. 425 U.S. at 442. Similarly, in Smith, the court held that a telephone user lacked a reasonable expectation of privacy in the phone numbers that he dialed because he voluntarily conveyed numerical information to the telephone company and exposed that information to its equipment in an ordinary course of business. ID at 744. The court doubted that people in general entertain any actual expectation of privacy in the numbers they dial, as it is common knowledge that users must convey numbers to the telephone company to place a call. In contrast, Galton is claiming a privacy interest in video footage of himself that his LLC pays to have recorded, including behind the scenes or lifestyle footage that he asserts is personal in nature. And importantly, he also claimed that he has the authority to control how the footage is used, including whether it is shared with his record company, uploaded to social media, or otherwise released publicly. This arrangement is not comparable to a person making a bank deposit or dialing a phone number and thereby conveying information to a bank or phone provider in a normal course of business to complete a routine transaction. Both because the footage at issue here contains personal information of a different nature than that contains in the business records at issue with Miller and Smith. See Carpenter 138 SCT at 2219. And because the bank depositor and the phone customer retains no authority to control the use of their information once it's conveyed to the business. Thus, the mere fact that the video was shared with or accessible to Ramsey did not by itself negate Galton's claim to Fourth Amendment protection and would not mechanically apply the third-party doctrine. To hold to the contrary, ID at 2219. Also see Finley 477 F3D at 259. That the defendant employer cannot have read the text message once he returned the phone does not imply that a person in his position should not have reasonably expected to be free from intrusion from both the government and the general public. Nevertheless, while I have concerns with the majority emphasis on property law concepts and disagree with its application of the third-party doctrine, I concur in the judgment because while Galton argues that he had an arrangement with Ramsey that conferred a legitimate privacy interest in the video, he did not carry his evidentiary burden to support that argument. Neither Galton nor Ramsey nor any other witness testified to the specifics of the arrangement between Galton and Ramsey. Evidence showing that Galton's LLC made a cameraman payment to Ramsey without more is not enough to establish that Galton had a reasonable expectation of privacy in the footage, and the testimony concerning Galton's relationship with Atlantic Records likewise does not establish the terms of Galton's relationship with Ramsey. So what Youngboy defense and the prosecution is arguing over is two rules: Rutgers versus Illinois and Miller versus Maryland. Youngboy defense team is saying that his case fall under these guidelines. Because if y'all familiar with case law, that's how it works, you know. Certain cases become a precedent for other cases. To be honest, this case might even hurt Boosie's, NBA Youngboys, that is. But the judge denied it. The judge saying because Youngboy didn't have a pre-got interest in that footage, but it's not his footage. So he can't claim privacy under those laws because, yeah, he got access to the footage. But the SD cards, the memory cards, is not his. It belonged to Ramsey. So he can't claim his privacy is being invaded in this situation. Major blow for his case. Because now the state got footage of NBA Youngboy holding the gun. They got the footage. Now I'm intrigued to see what happened next. And, I don't know if they're going to throw him a deal when he cop out or he's still going to try and fight it. But it looked like to me this Baton Rouge case is stronger than the federal case. Because if y'all can remember with the federal case and y'all seen some of the clips, a lot of that evidence got tossed out. But this Baton Rouge case with this information just got 10 times stronger. But let me know how y'all feel about it in the comments. Like I say, I don't know how much time he facing on this case. I ain't really looking into it. But I know he is facing jail time. You talking about a felon in possession of a firearm. And they was talking about something nice. Did y'all hear the firearm that they had him in possession of? Now, I'm not sure if he's getting caught or getting charged with all those guns. I don't think they can necessarily do that because they don't have him on camera with all those guns. I'm intrigued to see how that break down and who take those charges, if anybody. But as we know, as it stands right now, the footage that got tossed out a couple months ago, maybe a year ago now, can now be used. And it just made this case, the state case, that much stronger. But let me know how y'all feel about it in the comments. This is Keep It G News. Make sure y'all subscribe to the channel. Donate to the channel if you can. Subscribe, definitely. The favorite blogger. And I'm out.
You be dreaming about your dreams. I be living out my nightmares. I be missing out in bed. The other night she was right there. I be lurking with my bros. I be crying with my mom.